Preliminary provisions and basic concepts. National territory. What are included in the national territory of the Philippines? The national territory of the Philippines includes the following. 1. The Philippine Archipelago with all islands and waters embraced therein. 2. All other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains. 3. Its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. And 4. The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, which form part of the internal waters of the Philippines. Q. What is the Archipelago Doctrine? The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Under this doctrine, a straight baseline is drawn by connecting the outmost point of the archipelago and consider all waters enclosed thereby as internal waters. Cruz, Philippine Political Law, 2014. Q. By dropping the phrase belonging to the Philippines by a historic right or legal title, did the Constitution in effect drop the Philippine claim to Sabah? No. The clause neither claims nor disclaims Sabah. It has, however, avoided the use of language historically offensive to Malaysia, and has used instead the clause over which the Philippines has sovereignty or jurisdiction. The formula is recognition of the fact that unilateral assertions in a constitution, which is municipal law by themselves, do not establish an international right to a territory. Bernas, the 1987 Constitution, 2011. Q. By entering into UN clause and by enacting the baseline law, did the Philippines lose territory? No. UN Clause 3 has nothing to do with the acquisition or loss of territory. It is a multilateral treaty regulating, among others, sea use rights over maritime zones. Example, the territorial waters, 12 nautical miles from the baselines. Contiguous zone, 24 nautical miles from the baselines. Exclusive economic zone, 200 nautical miles from the baselines and continental shelves that UN Clause 3 delimits. On the other hand, baselines law, such as RA 9522, are enacted by UN Clause 3, states parties to mark out specific base points along their coasts from which baselines are drawn, either straight or contoured, to serve as geographic starting points to measure the breadth of the maritime zones and continental shelf. Thus, baselines laws are nothing but statutory mechanism for UN Clause 3 states parties to delimit with precision the extent of their maritime zones and continental shelves. In turn, this gives notice to the rest of the International Committee of the scope of the maritime space and submarine areas within which states parties exercise treaty-based rights, namely the exercise of sovereignty over territorial waters, Article 2, the jurisdiction to enforce customs, fiscal, immigration, and sanitation laws in the contiguous zone, Article 33, and the right to exploit the living and non-living resources in the exclusive economic zone, Article 56, and continental shelf, Article 77. Magalona versus Ermita. Q. What is the function of the Declaration of Principles and State Policies in the Constitution? The Declaration of Principles and State Policies is a statement of the basic ideological principle and policies that underlie the Constitution. As such, the provisions shed light of the meaning of the other provisions of the Constitution, and they are a guide for all departments of the government in the implementation of the Constitution. Bernas, Philippine Constitution Reviewer. Q. What is the nature of the Philippine state? The Philippines is a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. Constitution, Article 2, Section 1. It is 1. Democratic, as it is a participatory democracy. and contemplates instances where the people would act directly and not always through their representative. Tolentino versus Kamalek. And 2. Republican, as it is a representative government run by and for the people. Its essence is representation and renovation. Cruz. Philippine political law. Q. What is the foreign policy of the Philippines? The state shall pursue an independent foreign policy. In its relations with other states, the paramount consideration shall be national sovereignty, territorial integrity, national interest, and the right to self-determination. Q. Does independent foreign policy require the Philippines to be isolated from the rest of the world? No. The Constitution did not envision a hermit-type isolation of the country from the rest of the world. In its Declaration of Principles and State Policies, the Constitution adopts the generally accepted principle of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. By the doctrine of incorporation, the country is bound by generally accepted principles of international law, which are considered to be automatically part of our own laws. Tanyada versus Angara. Q. May the Philippines declare war? No. The Philippines renounces war as an instrument of national policy, adopts the generally accepted principle of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. However, it is to be noted that this provision speaks of an offensive war, not of a defensive war, as it authorizes the declaration of the existence of a state of war. Such defensive war is presumably commenced or provoked by the enemy state. Cruz. Philippine political law. Q. What is civilian supremacy and what is its basis? Civilian supremacy means that civilian authority is at all times supreme over the military. Constitution, Article 2, Section 3. The principle is based on the fact that sovereignty resides in the people and all government authority emanates from them. It is ensured by the installation of the President, the highest civilian authority, as the Commander-in-Chief of all the armed forces of the Philippines. 2. The requirement that members of the AFP swear to uphold and defend the Constitution, which is the fundamental law of the civil government. Q. Are members of the armed forces of the Philippines triable by regular courts? Yes. Section 1 of RA number 755 lays down the general rule that members of the AFP and other persons subject to military law, including members of the Citizens Armed Forces Geographical Units, or CAFGU, who commit crimes or offenses penalized under the revised penal code, like coup d'etat, other special penal laws, or local ordinances, shall be tried by the proper civil court. The exception is where the civil court, before arraignment, has determined the offenses to be service-connected. Then the offending soldier shall be tried by court-martial. The exception to the exception is where the President of the Philippines, in the interest of justice, directs before arraignment that any such crimes or offenses be tried by the proper civil court. Gonzalez versus Abaya. Q. What is the role of the AFP? The AFP is protector of the people and the state. Its goal is to secure the sovereignty of the state and the integrity of the national territory. Q. What is the prime duty of the government? The prime duty of the government is to serve and protect the people. For this purpose, the government may call upon the people to defend the state, and in fulfillment thereof, the citizens may be required under conditions provided by law to render personal, military, or civil service. Constitution, Article 2, Section 4. Note: the duty of the government to defend the city cannot be performed except through an army. To leave the organization of an army to the will of the citizens would be to make this duty of the government excusable, should there be no sufficient men who would volunteer to enlist therein. People versus Lagman. Q. Discuss the doctrine of separation of church and state and its consequences. The separation of church and state shall be inviolable. Under our Constitution scheme, it is not the task of the state to favor any religion by protecting it against an attack by another religion. Vis-a-vis religious differences, the state enjoys no banquet of options. Iglesia Ni Cristo versus Court of Appeals. Q. Discuss the state's independent foreign policy and freedom from nuclear weapons. The constitutional policy of a self-reliant and independent national economy does not necessarily rule out the entry of foreign investments, goods, and services. It contemplates neither economic seclusions nor mendicancy in the international community. Tanyada versus Angara. However, there is a marked antipathy in the Constitution towards foreign military presence in the country, or of foreign influence in general. Lim versus Executive Secretary. Moreover, the Philippines, consistent with the national interest, adopts and pursues a policy of freedom from nuclear weapons in its territory. Constitution, Article 2, Section 8. Q. What is the policy of the state on human rights? The state values the dignity of every human person and guarantees full respect of human rights. As the government is a chief guarantor of order and security, the constitutional guarantee of the rights to life, liberty, and security of person is rendered ineffective if the government does not afford protection to these rights, especially when they are under threat. Razon versus Tagitis. Q. Does the Constitution allow abortion? No. The Constitution affords protection to the unborn from conception. The clear and unequivocal intent of the framers of the 1987 Constitution in protecting the life of the unborn from conception was to prevent the legislature from enacting a measure legalizing abortion. The intention is to make sure that there would be no pro-abortion laws ever passed by Congress or any pro-abortion decision passed by the Supreme Court. Note: a reading of the RH law would show that it is in line with this intent and actually proscribes abortion. While the court has opted not to make any determination at this stage when life begins, it finds that the RH law itself clearly mandates that protection be afforded from the moment of fertilization. Moreover, the RH law recognizes that abortion is a crime under Article 256 of the Revised Penal Code, which penalizes the destruction or expulsion of the fertilized ovum. Spouses Imbong versus Ochoa. Q. What is the policy of the state on local autonomy? The state shall ensure the autonomy of local government. The territorial and political subdivision shall enjoy local autonomy. The above-quoted provision of the Constitution and the LGC reveal the policy of the state to empower local government units to develop and ultimately become self-sustaining and effective contributors to the national economy. Belgica versus Ochoa. Q. Is there a constitutional right to a balanced and healthful ecology? Yes. While the right to a balanced and healthful ecology is to be found under the Declaration of Principles and State Policies and not under the Bill of Rights, it does not follow that it is less important than any of the civil and political rights enumerated in the latter. Such a right belongs to a different category of rights altogether, for it concerns nothing less than self-preservation and self-perpetuation, aptly and fittingly stressed by the petitioners, the advancements of which may even be said to predate all governments and constitutions. As a matter of fact, these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of humankind. If they are now explicitly mentioned in the Fundamental Charter, it is because of the well-founded fear of its framers that unless the rights to a balanced and healthful ecology and to health are mandated as state policies by the Constitution itself, thereby highlighting their continuing importance and imposing upon the state a solemn obligation to preserve the first and protect, and advance the second. The day would not be too far when all else would be lost, not only for the present generation, but also for those to come, generations which stand to inherit nothing but parched earth incapable of sustaining life. Opposa versus Factoran. Q. What is the policy of the state on access to public service? The state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. Note, this provision does not contain a judicially enforceable constitutional right and merely specifies a guideline for legislative action. It is not intended to compel the state to enact positive measures that would accommodate as many as possible into public office. The privilege may be subjected to limitations such as the provisions of the Omnibus Election Code on nuisance candidates. Pamatong versus Kamalek. Q. What is the policy of the state on disclosure of matters of public interest? Subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. Article 2, Section 28 of the Constitution. Note, Article 2, Section 28 of the Constitution recognizes the duty of officialdom to give information even if nobody demands. This provision is essential to hold public officials accountable to the people. The absence of an implementing legislation is not an excuse in not effecting such policy. The Province of North Cotabato et al. Versus the Government of the Republic of the Philippines. Separation of powers. Q. Discuss the separation of powers. The principle of separation of powers refers to the constitutional demarcation of the three fundamental powers of government. To the legislative branch of government, through Congress, belongs the power to make laws. To the executive branch of the government, through the President, belongs the power to enforce laws. And to the judicial branch of the government, through the court, belongs the power to interpret laws. Because the three great powers have been, by constitutional design, ordained in this respect, each department of the government has exclusive cognizance of matters within its jurisdiction and is supreme within its own sphere. Belgica versus Ochoa. Q. What is the purpose of separation of powers? The principle of separation of powers and its concepts of autonomy and independence stem from the notion that the powers of government must be divided to avoid concentration of these powers in any one branch. The division, it is hoped, would avoid any single branch from lording its power over the other branches or the citizenry. Belgica versus Ochoa. Q. When is there a violation of separation of powers? Broadly speaking, there is a violation of the separation of powers principle when one branch of government unduly encroaches on the domain of another. U.S. Supreme Court decision instruct that the principle of separation of powers may be violated in two ways. 1. Firstly, one branch may interfere impermissibly with the other's performance of its constitutionally assigned function, and 2. Alternatively, the doctrine may be violated when one branch assumes a function that more properly is entrusted to another. In other words, there is a violation of the principle when there is impermissible interference with and or b. assumption of another department's function. Belgica versus Ochoa. Checks and balances. Q. What is the principle of checks and balances? This is the mechanism by which one department is allowed to resist encroachments upon its prerogatives or to rectify mistakes or excesses committed by the other departments. Natura, Outline Reviewer in Political Law, 2016. Q. What is the principle of the blending of powers? There are instances when powers are not confined exclusively within one department, but are assigned to or shared by several departments. It is often necessary for certain powers to be reposed in more than one department so that they may better collaborate with and in the process check each other for the public good. State immunity. Q. Discuss the principle of state immunity. the state may not be sued without its consent. The rationale behind this is that there can be no legal right against the authority, which makes the law on which the right depends. Department of Health versus Philippine Commonwealth. Q. What is the sociological basis of state immunity? Practical considerations dictate the establishment of an immunity from suit in favor of the state. Otherwise, and the state is suable at the instance of every other individual. Government service may be severely obstructed and public safety endangered because of the number of suits that the state has to defend against. Several justifications have been offered to support the adoption of the doctrine in the Philippines, but that offered in Providence, Washington Insurance versus Republic of the Philippines is the most acceptable explanation, according to Father Bernas, a recognized commentator on constitutional law, tweet. A continued adherence to the doctrine of non-suability is not to be deplored, for as against the inconvenience that may be caused private parties, the loss of governmental efficiency and the obstacles to the performance of its multifarious functions are far greater if such a fundamental principle were abandoned and the availability of judicial remedy were not thus restricted. With the well-known propensity of the part of our people to go to court, at least provocation, the loss of time and energy required to defend against lawsuits, in the absence of such a basic principle that constitutes such an effective obstacle could very well be imagined. Air Transportation Office versus Spouses Ramos. Q. May this principle be invoked by other states? Yes. Immunity is enjoyed by all states as such, consonant with the public international law principle, par in parem non habet imperium, that all states are sovereign equals and cannot assert jurisdiction over one another. Miniature versus CA. The head of state, who is deemed the personification of the state, is inviolable and thus enjoys immunity from suit. Natura. Q. What determines if the suit is against the state? The suit is regarded as one against the state where satisfaction of the judgment against the officials will require the state itself to perform a positive act, such as the appropriation of the amount necessary to pay the damages awarded against them. Department of Health versus Commonwealth. Q. May there be a waiver of state immunity? Explain. Yes. The Constitution provides that the state may not be sued without its consent. In order that a suit may lie against the state, it must give its consent, whether express or implied. Department of Transportation and Communications versus Spouses, Abesina. Q. How may the state give its express consent to be sued? Express consent may be made through a general law or a special law. In this jurisdiction, a general law waiving the immunity of the state from certain suits is found in Act No. 3083, where the Philippine government consents and submits to be sued upon any money claim involving liability arising from contract, express or implied, which could serve as a basis of civil action between private parties. Republic versus NLRC. Q. How may the state give its implied consent to be sued? The state may impliedly give its consent to be sued. 1. When the state enters into a private contract, unless the contract is only incidental to the performance of a government function. This concept of restrictive theory holds that the immunity of the sovereign is recognized only with regard of public acts, or acts jure imperii, but not with regard to private acts or acts jure justionis. Republic of Indonesia versus Vincent. 2. When the state enters into an operation that is essentially a business operation, unless the business operation is only incidental to the performance of a governmental function, as for instance, Arrastre Service Mobile, Philippines versus Custom Arrastre. 3. When the state sues a private party, unless the suit is entered into only to resist a claim, Lim versus Brunel. And 4. When the application of a doctrine of state immunity would serve as an instrument for perpetrating an injustice to a citizen, as when the state enters and takes possession of a private property without just compensation and without first initiating regular expropriation proceedings. Department of Transportation and Communications versus Spouses Abyssina. Q. What is the scope of the consent that may be given by the state? Where the state gives its consent to be sued by private parties, either by general or special law, it may limit the action only up to the completion of proceedings anterior to the stage of execution, and that the power of courts ends when the judgment is rendered, since government funds and properties may not be seized under writs of execution or garnishment to satisfy such judgments. Disbursements of public funds must be covered by the corresponding appropriation as required by law. Republic versus Villasor. Q. Do government-owned or controlled corporations also enjoy the immunity of the state from suit? No. A government-owned and controlled corporation has a personality of its own, distinct and separate from that of the government. Rayo versus Court of First Instance. Q. Are government agencies entitled to immunity? It depends. If the agency is incorporated, the test of its suability is found in its charter. The rule is that it is suable if its charter says so, and this is true regardless of the functions it is performing. Cruz, Philippine Political Law. However, if the charter is silent, one must inquire into its function based on the purpose for which it was created. Malong versus PNR. On the other hand, if it is unincorporated, then it has no separate juridical personality. Hence, as a general rule, suits filed against it are necessarily actions against the state of which it is part. Philippine Rock Industries versus Board of Liquidators. However, the need to distinguish between an unincorporated government agency performing governmental function and one performing proprietary functions has arisen. The immunity has been upheld in favor of the former because its function is governmental or incidental to such function. It has not been upheld in favor of the latter, whose function was not in pursuit of a necessary function of government, but was essentially a business. Air Transportation Office versus Spouses David. Q. Is there an exception to the rule of prohibition of garnishment of public funds? Yes. If the funds belong to a public corporation or a government-owned or controlled corporation, which is clothed with a personality of its own, separate and distinct from that of the government, then its funds are not exempt from garnishment. This is so because when the government enters into commercial business, it abandons its sovereign capacity and is to be treated like any other corporation. National Housing Authority versus Ears of Isidro. Give Londo. Note: before levy on execution may proceed, a claim for payment of the judgment award must first be filed with the Commission on Audit, which has the primary jurisdiction to examine, audit, and settle all debts and claims of any sort due from or owing the government or any of its subdivisions, agencies, and instrumentalities, including GOCCs. Agra versus Commission on Audit. Q. May a court direct the garnishment of funds appropriation to a state university to satisfy the unpaid balance of a construction project on the ground that the funds had already been earmarked for the construction project? No. A special appropriation by Congress is required before the judgment rendering UP liable for damages would be satisfied, considering that such monetary liabilities were not covered by the appropriations earmarked for the said project. The Constitution strictly mandates that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. University of the Philippines versus Dizon. Legislative Department. Scope and limitations. Q. Discuss the scope of legislative power. Legislative power is the power to propose, enact, amend, and repeal statutes. Bernas, 1987 Constitution. It is vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provisions on initiative and referendum. Article 6, Section 1 of the Constitution. Q. What are the limitations of legislative power? Legislative power is subject to 1. Substantive limitations, which involve the exercise of the power itself and the allowable subjects of legislation, and 2. Procedural limitations, which specify the manner of passing laws. Q. What are some of the substantive limitations? The following are the substantive limitations under the Constitution. 1. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people, peaceably, to assemble and petition the government for redress of grievances. 2. No law shall be made respecting an establishment of religion, or prohibiting the free exercise thereof. 3. No law impairing the obligation of contracts shall be passed. 4. No ex post facto law or bill of attainder shall be enacted. 5. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. Article 6, Section 25, Number 5. Number 6. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. Article 6, Section 25, Number 2. 7. Prohibition against use of public money or property for religious purposes. 8. No law granting any tax exemption shall be passed without the concurrence of a majority of all members of the Congress. Number 9. All money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. 10. Charitable institutions, churches and personages, or convents appertinent thereto, mosques, non-profit cemeteries, and all lands, buildings, and improvements used as religious, charitable, or educational purposes shall be exempt from taxation. 11. All revenues and assets of non-stock, non-profit educational institutions used actually, directly, and exclusively for the educational purpose shall be exempt from taxes and duties. 12. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. 13. No law granting a title of royalty or nobility shall be enacted. Q. What are the procedural limitations? The following are the procedural limitations under the Constitution. Every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title thereof. 2. No bill passed by either house shall become a law unless it has passed 3 readings on separate days and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. 3. A special appropriations bill shall specify the purpose for which it is intended and shall be supported by the funds actually available as certified by the National Treasurer, or to be raised by corresponding revenue proposed therein. 4. All appropriation, revenue, or tariff bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. Principle of non-delegability exceptions. Q. What is the rule on delegation of powers? The general rule is potestas delegata non delegare potest. Power delegated cannot further be delegated. This is based on the ethical principle that delegated power constitutes not only a right but a duty to be performed by the delegate through the instrumentality of its own judgment and not through the intervening mind of another. Q. When is delegation of powers permissible? There is permissible delegation in the following cases. P-E-T-A-L. Petal. 1. Delegation to the people of large. Examples are: A. System initiative and referendum. B. Requirement of plebiscite and declaration, division, merger, and abolition of LGUs. 2. Emergency powers of the President. 3. Tariff powers of the President. 4. Delegation to administrative bodies. 5. Delegation to local government units. Q. What are the tests for valid delegation? The tests for valid delegation are: 1. Completeness test. The law is complete when it sets forth therein the policy to be executed, carried out, or implemented by the delegate. And 2. Sufficient standard test. To be sufficient, the standard must specify the limits of the delegate's authority and identify the conditions under which the legislative policy so announced to be implemented. Abacada Guru Party List. Q. What is the composition of the Senate of the Philippines? The Senate shall be composed of 24 senators, who shall be elected at large by the qualified voters of the Philippines as may be provided by law. Article 6, Section 2. Q. What are the qualifications of a senator? The following are the qualifications of a senator: natural-born citizen of the Philippines, at least 35 years of age on the day of the election, able to read and write, registered voter, and 5. Resident of the Philippines for not less than 2 years immediately preceding the day of the election. Article 6, Section 3. Q. How long is the senator's term of office? The term of office of the senators shall be 6 years and shall commence unless otherwise provided by law, at noon on the 30th day of June next following their election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of office or any length of time shall not be considered as an interruption in the continuity of his service for the full term of which he was elected. Article 6, Section 4. Q. What is the prescribed composition of the House of Representatives? The House of Representatives shall be composed of not more than 250 members, unless otherwise fixed by law, consisting of 1. District representatives, not less than 200 members, elected from legislative districts, apportioned among the provinces, cities, and the metropolitan Manila area. 2. Party list representatives shall constitute 20% of the total number of representatives elected through a party list system of registered national, regional, and sectoral parties or organizations. 3. Sectoral representatives for 3 consecutive terms after the ratification of this Constitution. 1/2 of the seats allocated to party list representatives shall be filled as provided by law by selection or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. These members are referred to as sectoral representatives, and who were last appointed in 1995. What are the qualifications to become a member of the House of Representatives? A person must meet the following qualifications to become a member of the House of the Representative: natural-born citizen of the Philippines, at least 25 years of age of the day of the election, able to read and write, except the party list representatives, a registered voter in the district in which he shall be elected, and 5. A resident of the district in which he seeks to be elected for a period of not less than 1 year, immediately preceding the day of the election. Q. What is the term of office of the members of the House of Representatives? The members of the House of Representatives shall be elected for a term of 3 years, which shall begin, unless otherwise provided by law, at noon on the 30th day of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Q. What are the rules in the apportionment of legislative districts? The following rules govern the appointment of legislative districts. It shall be made in accordance with the number of the respective inhabitants and on the basis of a uniform and progressive ratio. 2. Each city with at least 250,000 inhabitants is entitled to at least one representative. Each province, irrespective of the number of inhabitants, is entitled to at least one representative. 3. Each legislative district shall comprise, as far as practical, a contiguous, compact, and adjacent territory. Note, the 250,000 minimum population is only applicable to the initial apportionment of legislative districts in the cities and not in the subsequent apportionment of additional districts. Party list system. What is a party list system? The party list system is a mechanism of proportional representation in the election of representatives to the House of Representatives from national, regional, and sectoral parties or organization or coalitions thereof registered with the COMELEC. What is the purpose of the party list system? The purpose of the party list system is to enable certain Filipino citizens, especially those belonging to the marginalized and unrepresented sectors, organizations, and parties, to be elected to the House of Representatives. Ang Bagong Bayani OFW Labor Party List versus Commission on Election. What is a political party? A political party refers to an organized group of citizens advocating an ideology or platform, principles, and policies for the general conduct of government, and which, as the most immediate means of securing their adoption, regularly nominates and supports certain of its leaders and members as candidates for public office. It is a national party when its constituency is spread over the geographical territory of at least a majority of the regions. It is a regional party when its constituency is spread over the geographical territory of at least a majority of the cities and provinces comprising the region. Q. What are the guidelines for screening party list applicants? The new 6-point parameters for screening party list participants are as follows. 1. 3 different groups may participate in the party list system. A. National parties or organization. B. Regional parties or organizations. C. Sectoral parties or organization. Number 2. National parties or organizations and regional parties or organizations do not need to organize along sectoral lines and do not need to represent any marginalized and underrepresented sector. 3. Political parties can participate in party list elections provided they register under the party list system and do not field candidates in legislative district elections. A political party, whether major or not, that fields candidates in legislative district elections may still participate in party list elections, but only through its sectoral wing that must separately register under the party list system. The sectoral wing is by itself an independent sectoral party and is linked to the political party only through a coalition. 4. A sectoral party or organization is one whose principal advocacy pertains to the special interests and concerns of a specific sector of the population. It may either be one who, A. represent the marginalized and underrepresented, or, like labor, peasants, fisher folk, urban poor, indigenous cultural communities, the handicapped, veterans, and overseas Filipinos, or B. lacks a well-defined political constituency. Example, women, security guards, LPG dealers, etc. 5. A majority of members of sectoral parties or organizations that represent the marginalized and underrepresented must belong to the marginalized and underrepresented sector they represent. Similarly, a majority of the members of sectoral parties or organizations that lack well-defined political constituencies must belong to the sector they represent. 6. The nominees of sectoral parties or organizations that represent the marginalized and underrepresented, or that represent those who lack well-defined political constituencies, either must belong to their respective sectors or must have a track record or advocacy of the respective sectors. The nominee of national and regional parties or organizations must be bona fide members of such parties or organization. And 7. National, regional, and sectoral parties or organizations shall not be disqualified if some of their nominees are disqualified, provided that they have at least one nominee who remains qualified. Atong Paglaum versus Kamalek, 2013. Note: the guideline set under the Bagong Bayani case was modified by the ruling of the Supreme Court in Atong Paglaum versus Kamalek to allow major political parties to participate in the party list system through their sectoral wings. Q. What are the qualifications for a person to become a party list nominee? The following are the qualifications for a person to become a party list nominee. Natural-born citizen, at least 25 years of age on the day of the election. Note: in case of the youth sector, he must at least be 25 but not more than 30 years old on the day of the election. 3. Able to read and write. 4. A registered voter. 5. A resident of the Philippines for a period of not less than 1 year immediately preceding the day of the election. And 6. A bona fide member of the party or organization which he seeks to represent for at least 90 days preceding the day of the election. Q. What are the parameters in the election of party list? There are 4 parameters in the party list election in the Philippines, to wit: 1. The 20% allocation. 20% of the total membership of the House of Representatives is the maximum number of seats allocated for party list representative. In other words, there is 1 party list seat for every 4 legislative districts seat. Number 2, the 2% threshold. A guaranteed seat for a party list organization garnering 2% of the total votes cast. The guaranteed seats shall be distributed in a first round of seat allocation to parties that receive at least 2% of the total party list votes. 3. Proportional representation. The additional seats, that is, the remaining seats after allocation of the guaranteed seats, shall be distributed to the party list organizations, including those that receive less than 2% of the total votes. 4. The 3-seat cap. Each qualified party, regardless of the number of votes it actually obtained, is entitled only to a maximum of 3 seats. Bennett versus Kamalek. Q. Discuss the constitutionality of the 2% threshold prescribed under RA 7941 for the distribution of additional party list seats. The Supreme Court in Bennett versus Kamalek struck down as unconstitutional the 2% threshold in the distribution of additional party list seats in the second clause of Section 11, paragraph B of RA number 7941. The court held that the continued operation of the 2% threshold in the distribution of the additional seats frustrates the attainment of the permissive ceiling that 20% of the members of the House of Representatives shall consist of party list representatives. Q. What is the effect of a change in affiliation of any elected party list representative? Any elected party list representative who changes his political party or sectoral affiliation during his term of office shall forfeit his seat, provided that if he changes his political party or sectoral affiliation within 6 months before an election, he shall not be eligible for nomination as party list representative under his new party or organization. Q. What is the rule on vacancies in the seats of party list representatives? In case of vacancy in the seats reserved for party list representatives, the vacancy shall be automatically filled by the next representative from the list of nominees in the order submitted to the COMELEC by the same party, organization, or coalition, who shall serve for the unexpired term. If the list is exhausted, the party, organization, or coalition concerned shall submit additional nominees. RA 7941, Section 16. Q. May the COMELEC allow the substitution of nominees of party lists for causes other than those provided under RA 7941? No. The COMELEC, despite its role as the implementing arm of the government in the enforcement and administration of all laws and regulations relative to the conduct of an election, has neither the authority nor the license to expand extend, or add anything to the law it seeks to implement thereby. The IRRS, the COMELEC issues for that purpose, should always be in accord with the law to be implemented, and should not override, supplant, or modify the law. It is basic that the IRRS should remain consistent with the law they intend to carry out. Loken versus COMELEC. Q. May the registration of a party list be cancelled and the qualifications of its nominees be questioned after it had been proclaimed winner in the elections? Yes. The Constitution grants the COMELEC the authority to register political parties, organizations, or coalitions, and the authority to cancel the registration of the same on legal grounds. The said authority of the COMELEC is reflected in Section 6 of the RA 7941. In the case of the party list nominees or representatives, it is the House of Representatives Electoral Tribunal, HRET, that has jurisdiction over contests relating to their qualifications. Although it is the party list organization that is voted for in the elections, it is not the organization that sits as and becomes a member of the House of Representatives, but it is the party list nominees or representative who sits as a member of the House of Representatives. ABC Party List versus COMELEC, 2011. Q. May the party list organization remove its representative in the House of Representatives and substitute another? No. A party list representative is in every sense an elected member of the House of Representatives. Although the vote cast in a party list election is a vote for a party, such vote, in the end, would be a vote for its nominees, who, in appropriate cases, would eventually sit in the House of the Representative. They have the same deliberative rights, salaries, and emoluments. Abayan versus HRET. Thus, they may only be removed either by expulsion with the concurrence of 2/3 of all the members of the House of Representatives, or by the Electoral Tribunal either to an election protest or co-warranty proceeding. Q. What are the rules on compensations of senators and members of the House of Representatives? The salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives approving such increase. Q. What are the immunities granted to members of Congress? The following are the immunities of senators and members of the House of Representatives. 1. Privilege from arrest. In all offenses punishable by not more than 6 years imprisonment, a senator or a member of the House shall be privileged from arrest while the Congress is in session. Note, it is available while the Congress is in session, whether the session is regular or special, or whether or not the legislature is actually attending his session. Session covers the entire period from its initial convening until its final adjournment. Members of Congress are not exempt from detention or crime punishable by more than 6 years of imprisonment. Number 2. Parliamentary privilege of speech. They shall not be questioned, nor be held liable in any other place or any speech or debate made in the Congress or in any committee thereof. Note, however, he can be subjected to disciplinary action by the Congress itself. Chavez versus JBC. Q. What are the requisites to avail of the privilege of speech and debate? The following are the requisites: that the remark must be made while the legislature or the legislative committee is in session, and 2. That they must be made in connection with the discharge of official duties. Jimenez versus Kabangbang. Q. What are the prohibitions imposed upon members of Congress? The following are the disqualifications and inhibitions imposed upon them. 1. Incompatible office. No member of Congress may hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including GOCCs or their subsidiaries, during his term without forfeiting his seat. Note, the general rule is they cannot simultaneously hold the incompatible office while serving their term in office. The exception is if it is shown that said other office or employment is an extension of their legislative position, is in aid of legislative duties, or is held by them in an ex officio capacity. 2. Forbidden office. Neither shall he be appointed to any office which may have been created or whose emoluments had been increased during the term for which he was elected. Q. What is the effect in case members of the Congress hold incompatible office? Forfeiture of the seat in Congress shall be automatic upon the members' assumption of such other office deemed incompatible with the seat in Congress. Adasa versus Bacana. Q. What are the parliamentary prohibitions imposed upon members of Congress? The senators and members of House of Representatives shall not 1. Personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Appearance as counsel includes signing of pleadings but does not include appearance pro se. Puyat versus de Guzman. Number 2. Directly or indirectly be interested financially in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any GOCC or its subsidiary during his term. And 3. Intervene in any matter before any office of the government for his pecuniary benefit or where he may be called upon to act on account of his office. Q. May a member of Congress who holds a business interest in a corporation awarded a franchise during his term invoke the principle of separate personalities between him and the corporation as a defense against the prohibition against financial interest? No. A member shall not be interested financially, directly or indirectly, in any contract with or in any franchise or special privilege granted by the government during his term. The defense of separate personalities is inapplicable as the law prohibits even an indirect financial interest. Q. May members of the Congress practice their professions? Yes. As to the members of the Congress, there is no general prohibition as to the practice of their professions except for members of the bar whose practice of law is constitutionally limited. Q. What does the phrase "in any other place" means in Section 11, Article 6 of the Constitution? This section was taken or is a copy of Section 6, Clause 1 of Article 1 of the Constitution of the United States. In that country, the provision has always been understood to mean that although exempt from prosecution or civil actions for their words uttered in Congress, the members of Congress may nevertheless be questioned in Congress itself. Observe that they shall not be questioned in any other place than Congress. Furthermore, the rules of the House recognize the House's power to hold a member responsible for words spoken in debate. Osmania Jr. versus Pendatun. Q. What is the rule on disciplining members of Congress? Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension, when imposed, shall not exceed 60 days. Article 6, Section 16 of the Constitution, Paragraph 3. Q. What are the constitutional requirements for the passage of laws? Every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title thereof. No bill passed by either House shall become a law unless it has passed 3 readings on separate days, and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. Section 26, Paragraph 2. Note: all appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendment. Article 6, Section 24.